call this meeting of the Enfield Zoning Board of Appeals to order at 7:01 p.m. Please stand. There's 2 ways out of the room. One's behind the audience, down the stairs, out onto the town green. One's to the right of the audience, down the stairs, and into the parking lot. Let's stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, roll call, please.
Okay. Andrew Obanowitz.
Here.
Mary Ann Turner, here. Charlie Masterbirdy.
Here.
Rich Stroney.
Here.
Christine does not. Jim Byrne.
Jim,
Here.
Thank
put your
you.
mic on too. Thanks. Okay, on to old business. Madam Secretary, the legal notice.
Do I make the motion to move things around?
Oh, yeah,
or
you
wait
can
till
do that.
after?
Yeah, you can do that
I'd like to
first.
make a motion that we move item D, XZBA 2026-428, 37 Bacon Road, in front of ZBA 2026-410A and 2026-410B.
Second.
All those in favor? Motion passes. The agenda is modified.
Now what?
Now, legal notice.
Okay, ladies and gentlemen.
Oh, I'm going to seat him when I open the hearing.
I have to recuse myself from the
You
firehouse.
can't be seated in the firehouse. Okay.
Ready, set? The Enfield Zoning Board of Appeals will hold a public hearing at their regular meeting on Monday, June 22, at 7 p.m. in the council chambers, 820 Enfield Street, Enfield, Connecticut, concerning the following. XZBA 2026-4-28, 37 Bacon Road, application for a variance seeking relief of accessory structure height and location requirements under section 3.30.7A double I and 3.30.7A James Nolan applicant, Shaker Pines Fire District Number 5, owner, map 94, lot 62, I-1 zone. Thank you.
Thank you.
And with that, the applicants can come forward. And for the record, Commissioner Byrne is recusing himself from this matter and will be leaving the room. So we'll give him a moment. Okay. And just for the record, guys, variance can be granted where such grant will not affect the overall purpose of the zoning ordinance and where strict interpretation of the ordinance will result in a hardship. A hardship exists where the zoning ordinance uniquely affects a parcel of land differently from other properties and where use of the property or reasonable use of the land would be impossible without the variance. Self-imposed or financial hardships cannot, by law, be considered as a reason for granting a variance. Tell us about your application.
We need our names for the record.
Sure.
Can you check and see if that light is on?
It's on. Jamie Hurley, Hasbro Fire District 385 Hazard Ave.
Jay Flanagan, Thompson Fire, 85 North Main Street.
Behind us is James Nolan, Jim Nolan from Shaker Pines Fire District as well. So he may pipe in if.
I think you need to move the mic because I don't think it can hear you. Start yelling a little louder.
Testing.
That works.
Yep. Okay. So what we're trying to do is build a container-style training building on the property at the Shaker Pines Fire Station on Bacon Road. In the process of doing so, we learned that we don't comply with a couple pieces of the regulations because of the zoning areas. So we're in I-1 zone, I believe, which was the issue with the last agenda item. So we're in I-1 zone. We're completely surrounded by I-1 zones. However, across the street, there is an I-1/R44 zone. So that's brought us to here. Some of what we're trying to do with the training building does not comply because there's a residential zone. So we don't meet the requirements on height and the setback behind the main fire station. So some of the hardships we have with that is a height requirement is a necessity for us for training. We have to have a building somewhere in that 25 feet range where your requirements say it's 15 feet, I believe, right? So we have a challenge with that to meet OSHA, meet NFPA, and meet requirements for fire department training. we need to have 3 stories for us to be able to do that. So that's one area where we won't be able to meet that regulation of the 15 feet minimum height requirement. The other hardship we have is due to the way the property is laid out, the way the angle of the fire station sits on the property, and then there's some other constraints with some water areas. There's some flooding issues around the back part of the fire station. We struggle with being able to put the building completely behind the fire station as it sits right now. So there's a cell tower right there. There's a concrete shed that's right attached to the cell tower. The other challenge with that is we need to have a building that we can drive fire apparatus completely around for training. So where we tried to situate this training center is adjacent to the firehouse, where we have that complete access, where we can drive fire apparatus completely around. So those are the 2 things that we're hoping to get some relief on, is the height and that setback requirement. Miss anything?
Questions of the commission?
Could you show me what you're talking? I went out to the fire station, so I guess maybe you just need to educate me, the driving around part. I mean, I walked across the lawn.
Yep.
I parked in a handicap spot, don't tell anybody, because it was there, and I was just going in the back to see it.
Yep.
There's your parking, there's the building. How the heck, I don't remember there being a road that goes, or a driveway around it.
There's
Am I
not
missing
current-
it?
No, not currently. So if, I don't know, can you guys see the paperwork that we gave? I don't know.
Yeah, we have
Yep.
that.
So where that kind of sits, if you're in the back of the building, there's a hydrant right there, probably right where you were parking in the handicap spot. There's a hydrant right there.
That's this.
Yep.
Yep.
So the training building is going to be adjacent to that side lot where the
Right,
firehouse is.
because I saw you had it staked.
Yep, and then we want to, that's where the building is going to be, and we want to be able to drive a fire truck completely around that. So that
Around
it's not,
that?
It's not going to be in the grass. There's going to be,
You're gonna make a road?
yeah, not road, but we're hoping to
Dirt
get
path.
millings. Yeah,
You can put millings down something?
yeah,
So are
something
they
to keep
gonna,
fire truck from
they're
sinking
gonna
down.
come in from the parking lot, and then they'll drive up to this
Correct, yep.
thing, and then they'll be able to drive like a circle?
Correct, yep. And there's another requirement that we have to maintain is if we put training on a fire department facility, the fire department facility has to be able to function while there's training. So the other hydrant is on the other side of the apron, the other side of the bays. So we would block fire apparatus from coming in and out of the fire station. So the hydrant that's in the back lot is the only hydrant that would be accessible for training, so we don't block apparatus from coming in and out. So
Okay.
there's a lot of requirements that we have to maintain that are above and beyond, that kind of create some of these hardships.
So I just have a question, don't take this in any way, but don't we have one of these facilities over on Weymouth?
It's slightly different, and I think it might be almost outdated, but it's portable. It's a propane,
Yours or this?
the one in
The
Enfield.
one that they have?
Yep, it's a propane-based trailer, and what we're looking to do is have a multifaceted element of training. So there's not only live fire training with Class A materials, that just gives you a different type of training with smoke and different fires. But also we have some technical rescue training that we can do in this building, some higher angle training. And then that requirement for the 3rd story is a benefit for laddering, putting aerial devices up to that. That's needed for different types of training too. We can't accomplish that at the,
Who are we training? Just
Our
your
own
guys?
folks, yeah.
Or any of the fire departments?
we're hoping all 5 districts in Enfield.
Everybody plays?
Yep.
So it's an opportunity to
Yeah, absolutely.
to join together? Okay.
Yeah, correct.
But so nobody else has, because I can't think of any other fire station that has this other than the one on Weymouth. Has a something? Okay.
Any other questions of the commission?
Yeah, just real quick, the placement of the new shed, right, the training building, you're still able to drive around the back of that even though it's wetlands? Right, well, the 100-foot non-disturbance for wetlands, that's off to the, I'll call it the left side of the building,
The corner, right?
the corner there? That's not an issue for you guys?
We didn't need that. We only need 15 to 20 feet to be able to go around.
From where you're putting the building, just around.
Just to get around it, okay.
Just get around.
Okay.
Not going
you know, I'm more concerned, I don't want you having other issues down the road with
We
that.
weren't looking to go any further towards that
Yep.
wetland area. Like you said, it's that 15 to 20 feet. Normally, we're just trying to make it like a normal road.
Yep.
So it mimics what we have in the streets.
Right.
Right.
We're not
Yeah.
looking for a big, large area, so something really, really small to go around, so
Just enough to get the fire truck around.
Sure,
staying away from that area also.
okay.
Because I think you're talking about that corner.
Yeah.
Just everybody.
That corner.
I can't tell the width here, but I'm assuming you measured this? Let's not cause them an international incident just 'cause. That little corner, let's consider that,
Well, there's a scale on here.
right?
1 inch is 40 feet.
Oh, mine, it must be on the wrong map. Or the wrong side.
If the question is about whether wetlands would be an issue with having a little dirt path going around,
Yep.
we can give them we may be able to give them an agent approval as it's minimal impact. It's just within the upland review area, so that's something that could be given an agent approval through the planning and zoning
Okay.
office.
Yeah, I just don't want a further issue, and I assume because it's a gravel, it's not a,
At that
it's,
corner.
it's a permeable surface, so it's
But
less
this
of an
is
issue.
just the red
Correct.
If it was
area.
truly
This is
paved.
the actual
Correct,
area
and
back here.
to staff's understanding, they're not planning on parking the fire trucks over there just for the operation
Drive
of
in, go around,
officer
drive out.
fire department training. So that being a minimal impact use, that's something that can be done with agent approval.
Okay. Yeah, I just didn't want to create other complications with that, but, okay.
Of course.
Thank you.
So can you make sure that that little agent approval part is written so that they have it in their documents and not something we just said here?
We do have an official document for the agent approvals. That will be something that we can give to them through the building permit.
Works.
Any
Just
other-
making sure.
Any other questions? Do we have a motion?
You want me to read it?
Well, motion to close
I make a
the
motion to
hearing.
close the hearing.
I'll second
Okay.
the motion.
All those, and then now a motion to,
Okay, let's see here. Hold on, I gotta catch up. Motion to approve XZBA 2026-4-2837 Bacon Road application for a variance seeking relief in accessory structure height and location requirements under section 3.30.7A double I and 3.30.7.A double I dash B, dot B. James Nolan applicant, Shaker Pines Fire District Number 5, owner, map 94, lot 62, I-1 zone. So I made the motion. Who's,
Rich seconded.
I'll second it.
And you want to do, let's do a roll call since we keep it consistent.
hold on. So the thing with the variance, all those in favor gets the variance, those
Yep.
opposed do not get the variance.
Correct.
Okay, Andrew Abanowitz,
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy?
Yes.
Rich Stroni?
Yes.
Motion passes. Congratulations, guys.
So what's the reason for the approval?
Thank you.
The topography of the land and compliance with state fire training statutes.
Commissioners, I might ask quickly, who gave the second to close the motion?
Rich.
It was, thank you.
Do we have to read the legal notice again? Or we just reopen it?
You don't have to, because it's a continued hearing. So you don't have to read the notice. We usually do, but,
Well, he didn't have it on there, so,
so, yeah, I don't think you need to worry about that.
okay.
If you guys are ready, we'll call them up. All right, next, we're moving to item B on the agenda, 2026-4-10A, 174 Shaker Road. And we'll also resume with 2026-4-10B, 130 Shaker Road.
Good evening.
Welcome back. Name and address again for the record, guys.
George Schober, Schober and Schober, attorney, Enfield, Connecticut. And with me is Joseph Rashi, who is the owner of both 174 and 130 Shaker Road. I guess to start with, Mr. Stroini was not here last meeting. Can I ask if you're familiar with the record, sir, and would be able to vote tonight?
I've reviewed the minutes from last month and the material in front of me, so I'm prepared to vote as appropriate this evening.
Okay. Just because I do want 5 people voting, as we
I
need
don't blame
4 to overturn the decision. All right, so the first thing is just a bit of housekeeping. I just wanted to mention that I believe that the minutes of the last meeting are incorrect as to one point that I think is a fairly important point, and that is on page 2, and it's at the bottom of 130
Hold on
Shaker Road.
1 second.
Yes.
Minutes.
I wasn't here, so.
Oh. We got a copy to share, I guess.
You have a copy of the minutes?
The minutes are also available online with Civic Clerk.
We need to read them
We need
now.
the packets still printed for this board.
Do you have a
Here,
copy?
I've read them, I printed them from home.
May we use yours? So you share yours that way, and we'll share ours this way. Sorry.
Oh, not at all. So I'm on page 2, down at the bottom. Mr. Richelli received an email from Attorney Schober on April 28th, 2026, stating that Mr. Rashi will have the mulch piles and large shipping containers removed by May 31st, 2026. The substance of that is correct. However, that should be on 174 Shaker Road, which is Mr. Rashi's house, and that's where the trailers and the wood chip pile or mulch pile were being removed from, not from 174. So I just wanted to note
Okay, I'm
that.
confused. It says,
Yeah, it's just a street address.
so it says here 130 Shaker Road.
Right, but that's not correct. It
Is
should
it
be
supposed to be
174.
174?
Correct.
Okay.
So I just wanted to point that out.
Okay, we can make that change when we get to the minutes.
Right. All right. So I wanted to start, I've subpoenaed the town assessor to go over the field cards the assessor's cards from 2003 going forward to explain, there was some question as to what happened or what might have happened with the assessment and why this property was declared as an in-law property as opposed to just a single-family residence. So I have the town assessor, Mrs. Rose, here. I don't know, I need to question her, and I don't know how you do this in this room, in this situation. Do we put her up over here?
Who's she?
Mrs. Rose, the town assessor?
Or assessor. You don't know Vicky?
No. I think,
Hi, Vicky. Wherever she would be most comfortable, but we need to make sure that we're videoing this too, right? So where would that work? Should she sit next to him at the?
I was gonna say she can sit next to
Charlie.
Commissioner Charles, correct?
Okay.
Mr. Chairman, may I? I'm remembering the last time we were here, there was some discussion about Mr. Richelli going and visiting the property.
Right.
And I'm wondering if he did visit the property and if he found an in-law apartment. That might reduce the need for the examination of the assessor.
Well, I don't want to stop them from putting on their case, and they do have her here under a subpoena, so I don't really want to tie her up all night. So let them do their questioning first, and then we'll let Mr. Richelli tell us what he found.
Very good, thank you. Mrs. Rose, would you come up and
We did last time, so
that's-
yeah,
that's
he's, yeah.
continuation of that.
take the stage?
Don't look so excited.
So I have 6, including one for Mrs. Rose, which should match up with what she has.
copy.
So where are we about exhibit? Are we exhibit 5 on this? Do you know?
You have to be careful when you stand, they can't hear you.
Sorry.
There's a microphone
Yeah.
there, you can hold it in your hand and talk to us.
Oh, I was going to sit. I was just.
Okay.
Okay.
Yeah, thanks. Do you know, Mr. Heine, are we on exhibit 5? I can check my notes if. It's tonight. I think it might be 4, actually.
That's what I was thinking. I'm just double checking to see what you've given us at the last meeting.
I think it was 3 packets. He's up to 4.
He is up to 4? All right. So this is the 4th exhibit you've
Very
given to
good.
us.
Very good, thank you. All right. So, Mrs. Rose, you and I spoke a few weeks ago, maybe 3 or 4 weeks ago, and we took a look. I had requested field cards, and we took a look at the old field cards, and I had asked if you could tell me what this field card said regarding what type of building or structure this was. And can you tell us what type, according to this field card from 2003, what type of structure is this on this card?
It was designed as for one family, and it had plumbing as an additional plumbing, which I think is for extra kitchen.
For an extra kitchen, right. But the card itself, if one were to look at it, is there a code somewhere that tells you what type of building this is?
No, other than where it says designed one on the second page,
On the second page,
above ranch.
I'm sorry?
Above where it says ranch, there's a number 1, a couple of lines above.
And if it's,
You know where?
can you sort of tell us where that is on?
It's on the left side, in the middle.
Right.
It says designed one,
Designed
and
to
then
be
it says
1
ranch.
Style Ranch, designed 1, number living units 1?
Right.
So would that indicate a single-family house?
I guess. I mean, I wasn't the assessor back then, so I don't know if it would, what it would read like if it was had an in-law, but I think it would say on here that it was an in-law
Okay.
somewhere.
All right. So now, I have what we can mark as Exhibit 5, which is, I believe, this was from 2003, correct?
Yes, when the house was built.
All right.
So you're following along? Mm-hmm. Sorry, I have a tendency to spread.
Yeah, well, not the only one tonight.
Now, Mrs. Rose, can you tell the next document, which we're marking as Exhibit 5, can you tell the date on this document, what assessment year this would have been?
2006 reval.
2006 reval. And can you tell how many units this reval classified this house as?
It was the same as in the 2003 card.
So still classified at what we think would be a single-family
Right.
house? Okay. So this would be number 6.
same thing. Sorry, I'm spreading them apart, sorry.
Have another copy.
All right, so exhibit number 6, is there a date on this? Can you tell what this is?
This is from the 2011 reval.
All right, and it says
Hold on.
vision, I'm sorry?
Where is it? Where does it say that? Because it's different than the first two.
Right.
It says it right here.
Thank you.
When you say it says it right here, that's up in the right-hand corner?
Nope, right here.
Ah,
Where it says previous assessment history, the 2011 is on the most.
It's in the middle.
oh, right,
Like right under current assessment.
yes,
Yeah,
okay. So this was done by a different company, is that correct?
this was done by Vision
Yeah.
for the reval.
For the reval. Had Vision, to your knowledge, done the 2007 reval?
The 2006 reval.
2006?
No.
No. And the initial field card or assessor's card from 2003, was that a Vision card?
No.
So this is the first Vision card.
Yes.
And were there any other field cards that you located between 2003 and 2011?
No.
Just these 3? 2003, 2006 or 7, and 2011?
Right.
Okay. Now, how does Vision's card from 2011 classify this property?
Single family with in-law.
With an in-law. Now, I know you weren't working for Vision in 2011, correct?
Correct.
And you don't work for Vision now?
No.
You're a town employee as the
Yes.
town assessor?
Yes.
All right. And do you know, can you tell from this card, if anyone from Vision entered the property, by the property, I mean the house itself, not the outside of the property, but inside the property?
Nobody entered. You can tell by the visit history. It says call back, no entry.
Where's that?
Visit change
In
history.
the lower corner here. Call back, measure, no entry, prior inspection, 2007.
Thank you.
Okay, so there was no entry, and Vision somehow classified this as an in-law apartment. Do you have any idea why Vision may have, someone from Vision may have done that?
No.
Do you think it's possible that it was because of the plumbing for the second kitchen?
Perhaps. I mean, I do have their data collection card, which you didn't request.
Well, I requested it, that you bring everything for
Right,
tonight in the
so,
subpoena, but, so what does the data collection card tell us?
So it was, it was written down as a 101, and they crossed it off and put 107, which is the code, the state use code for in-law.
So 101, would that be a single-family code?
Right.
And 107 is an in-law code?
Right.
And are there any other notes on the data collection card that would indicate why that was done?
No.
No, okay. Is that a copy that I may have?
Well, I didn't make you a copy, but you can have it. if you
I can
want.
have it, because you can get extras, right? All right, so I'd like to enter this as, I believe it would be 7.
That is correct.
We only have the one copy, so let me get back to my seat, I guess, or, well, that doesn't work.
Did you give them the handheld?
Do we have a handheld? Oh, all right.
It's on the desk.
Is it?
It's always kept over there.
No, they don't always put it out for the meetings. He might bring one in if he hears us.
So there's a note on here under notes, 6/11/08 blue. Do you know what that means? Here you go. Ah,
you.
thank you. Is this on? Can you tell? How do we know if this is?
We can hear you.
You can hear me without it.
Yeah, but they have to hear you.
How do we know if they can hear me?
He'll come running back.
All right, fair enough. This note here 61108 blue. Do you know what that means?
I think the 611 is because they went out in June they went out June 8th of 2011, and the color of the house is blue.
Ah, okay. And then there's a 10 o'clock notation. Is that perhaps the time
The
it
time,
went out?
probably.
Okay. So there's no other notes in your file that would indicate why this was changed to an in-law?
No.
Okay. This is 7.
What you just passed, that would be Exhibit 8, because what you received from,
Right, was 7.
Correct.
Yes, thank you. All right, so what exhibit, you're looking at what is Exhibit 8, Mrs. Rose. Can you identify this document?
Looks just like the thing we're looking at.
It would be the 2016 reval card.
2016 or 2017?
Right there.
Well, I mean, it's technically 2017, but based on the 16 reval,
Okay, very good.
the assessment didn't change.
All right. And do we have any documentation here as far as whether or not Vision was able to enter the house itself?
Well, 16 would have been statistical. They wouldn't have gone out and they wouldn't have gone into the houses
Okay, so,
during that reval.
so we know that they didn't go in 16.
Correct.
Okay. And when you say a statistical, what is a statistical reval?
Well, they don't go to every house. They just do field review and
Okay.
based on the market.
All right.
It's
And
statistical.
in this particular revaluation, is the house still classified by Vision anyway as a one-family with an in-law?
Yes.
thank you.
Nine. All right, can you tell us what Exhibit 9 is, Mrs. Rose?
This is from the 2021 reval.
All right, and from this document, can you tell if anyone from Vision Appraisal was able to enter the house?
No, but that was during COVID, so they did not go into any homes at that time
Okay,
for that reval.
and that's where it says measure no entry,
Correct.
and on 6/16/2020?
Right.
All right, and how is the house classified in this,
The 107.
I'm sorry?
The single family with the in-law.
Okay, single family with an in-law. And is that how the house is still classified today?
Yes.
Okay. Has there been a revaluation since then?
It's going on right now.
Okay. So You haven't been inside the house, is that correct?
Correct.
All right. Now, I subpoenaed, I guess, basically most of your file. Is there anything besides these field cards and that data sheet that you brought with you?
No. No, I got the 2020 data collection.
All right, may I take a look? And right on that data collection sheet, it says COVID no entry, correct?
I wrote that
Oh,
today.
you wrote that, okay.
Sorry,
okay.
just for my
Okay.
own notes.
Understood. Those are all the questions I have for Mrs. Rose. I don't know if the commission has any questions for you before you step down.
Any questions from the commission for,
I do have one,
Mr. Rose?
if I could.
go ahead, Rich?
On the original, I'll call it Exhibit 4, I think it was, on the second page, it says additional fixtures 1. What does that mean? Second page, left column.
On the 2003,
Yeah, on the 2003. Sorry.
that's like an extra sink.
Correct.
Okay.
It could be it's
Or
just an extra,
extra something.
an extra sink in the like if the bathroom has two
Oh, okay,
sinks instead
okay.
of one.
Right, if there's like a utility sink or.
Got it. Okay.
Is that what we're talking about, additional
Yeah.
fixtures?
And then I had, I think, on the Exhibit 6, the attorney, the 2011 dated one.
Yeah.
It says extra kitchens 1. And I think that's the concern that was raised here, correct?
Can you show me where you're at? Which number is it?
It's
This
the
one?
one says 2011 in this box.
Yep.
Second page just says extra kitchen 1.
It says 1.
Yeah.
And then, what is it for Mrs. Rose? The, up top it says occupancy 2. What does that mean? Is that just a code being 2, or is that the number of units in the building?
I think that's referring to 2 units, but it's within the it's a single family with in-laws,
Oh,
so
okay.
it would be 2
Okay,
units if
okay.
that's what.
Just trying to understand these cards.
Oh, you're on the vision card.
Yeah.
Yeah, I was on the
Yeah,
vision
yeah.
card, yeah. Okay,
Yeah, that's what they do for either a two-family.
okay, thank you. That's all I had, Mr. Chairman. For
Okay.
now.
And nothing further from council?
No.
Hey,
Uh,
1 second.
You have one
So
more
just-
question?
Just because I'm being educated with your cards, if you don't mind. So the first ones, when he first built it, then the next one, before we got to this thing with the in-law apartment stuff, there's no, unless I'm reading this wrong, where does it say there's a kitchen, second kitchen, on the original, the 3?
I believe it's where it has the plumbing. They're just being valued for the plumbing of a kitchen.
So it
It
doesn't
was
say
a-
extra kitchen?
No, it
says-
just says
Just where
plumbing.
it says plumbing plus? Right, okay, it's just a dollar amount or a assessed value,
Correct.
right?
You okay now, Mary Ann?
Yep,
All right.
just being
Okay,
tutored.
thank you, Vicki. You can leave.
Thank you very much.
Excuse me. I have a question, a couple questions, if I may.
For the assessor?
Yes,
Okay. Yeah.
if you don't mind, just, it being considered 2 units, a single family with an in-law, is it taxed any more or any differently than a single-family home?
I don't think so. I would have to double check. Because the extra kitchen is the value mostly.
It's valued mostly for what's included within the home, so it would be
Right.
taxed more because of the second kitchen.
Right. I don't know if the landline really would make a difference.
And whose responsibility is it to determine the the taxes that an individual property owner is responsible for? Is it the homeowner or is it the town?
You mean,
Well, is it the responsibility of the homeowner to know what he's paying in taxes or what he's paying taxes for?
oh, I don't know, I guess. I mean, I'm the one that signs the grand list, or a prior assessor would have signed the grand list.
Okay.
I mean, I guess I don't understand your question.
I guess the question is, if I'm a homeowner, should I be expected to know what I'm being taxed at?
I mean, if you have a computer and and you go on Vision's website, I mean, a lot of people don't.
A lot of people
look it
don't,
up.
but
Right.
they still would be able to know what they're being taxed for.
They could look it up online, correct.
That's it. Thank you.
Hi.
Hello. My question is, did your file reflect that any appeals were taken on this property, any assessment appeals since 2003?
I'd have to look. I mean, in Vision, we've been keeping it on the card, so nothing's happened since 2011.
Okay.
But for prior than that, I'd have to actually go back and see if there was ever an appeal filed.
Was there any correspondence or any notes about conversations that the homeowner had with
No.
your office? No.
No.
Okay, thank you.
Everybody set? Okay, you can go now for real this time, Vicki. Thank you.
All right, so just for sort of a recap of last time for Commissioner Stroini, who, if you didn't listen to the whole thing, we had shown how Mr. Rashi had complied with, he designed a plan from a modular home company in Colchester. He presented that plan to the building official. The building official had him make a change because the building official had told him that the way it was designed, it would be considered a two-family house, which would not be authorized in the industrial zone. And he had obtained a special use permit to build a single-family home in the industrial zone. So he made that change. Those plans were approved by the building official. They were signed off by the zoning department at that point. It went through the entire compliance from pulling the building permit to building the house, and he built it exactly in accordance with the plan, or the building inspector wouldn't have signed off on it, and that's what the building inspector did. Further, Mr. Rashi testified that he has not made any changes. He hasn't put the door that was required to be removed or taken from the plan. He hadn't put a door back up to separate what was the initial area where his mother was living. So all along, this was a one-family home, and you just heard what we think happened, which is when Vision came in and they saw the extra plumbing, figured out it was an extra kitchen. I mean, it was assessed for $9,700 or $9,100 in 2003. That's not a half a sink or something. That's the kitchen, and that was on the plans, and the plans are in the file. The entire building file is in the record of this hearing for this appeal. And that's the house. And so had Vision not come in 2011, I don't think we'd be here. But Vision did, and here we are. So I just wanted to make sure that you were fully aware of the backstory. And now I think how we got here. So I did want to ask a couple of questions of Mr. Rashi. How many furnaces are in this in your house?
Just one.
And that would be then how many electric services are in your house?
One.
And telephone lines that come into the house?
One.
And the same with cable?
Yeah, one.
Okay. All of these utilities are on 1 meter, is that correct?
Yes.
And were they on 1 meter in 2003?
Yes.
And had they ever changed from 1 meter, any of these utilities between 2003 and now?
No.
All right. Now, at the last hearing, I believe Mr. Richelli mentioned that you had admitted to him at some point in some conversation, and then we got sidetracked and I didn't ask you about this, that you admitted that there was an in-law apartment there. Do you remember hearing that?
No.
You don't remember hearing, you don't remember?
Oh, I remember hearing it at the meeting. I just
Okay.
don't-
Do you remember a conversation with Mr. Richelli regarding whether or not there's an in-law apartment here?
No.
All right. Do you remember ever speaking with Mr. Richelli without me present?
No.
All right. I think that that is all that we have. We did not have Mr. Richelli. We did not invite him in, as my client does not believe, and I recommended to him that he does not have to do this, that there is any basis for Mr. Richelli to come into the house. The house hasn't changed. Vision didn't come into the house to locate or see any changes. The house is as it was, and Mr. Richelli testified to that. And his privacy and the privacy of his family shouldn't be disturbed because someone looked at a field card that Vision changed on its own after he's done everything he was supposed to do starting in 2003. And the only reason we're here is because he happened to place, a neighbor complained because he had trailers in what might be considered the wetlands. Now, they're not flagged, so we don't know, but he's removed the trailers. They're gone. So that's why we're here, though, is because somebody complained and Mr. Richelli looked at the field card. Not because there's any evidence that it's a two-family home or a home with an in-law apartment, and the only people living in there are relatives. And that is allowed by your zoning regulations, and we submitted that last time into the record. So I would suggest, and I would state that I would ask that this cease and desist order be overturned by this board.
Okay there? Okay, I'm going to let Rick comment. So Rick, why don't you update us on anything on your end that's happened?
So I would
since
only
last
say that this matter's been going on since February of 2022, when the first notice of violation was issued to the property owner, and he was represented by Attorney Schober then. So they've had 4 years to correct this issue of it being on the property card as an in-law apartment. And they've had every opportunity to do so. They were the ones that made the offer for me to go into the house during the last meeting to check and actually determine firsthand if that was the case. I can only go by whatever I have. The cease and desist order was issued based on what was available at the time and whether or not there was a violation for it being considered an in-law apartment. And that's basically what the appeal is. Was it at the time when I issued the cease and desist order a violation because there's no special permit or there's no approval for that use? And that's what the board needs to make a determination for.
And the other issues on the site, to your mind, have been resolved, or?
I'm not sure. As of, they sent a letter regarding the containers and the mulch pile being removed by May 31st. That wasn't done. The inland wetlands agreed to that.
Sorry, they agreed to.
They agreed to allow them to have it removed by, they asked for an extension so that they could have time to remove the mulch pile and the containers, which also need a special permit approval in an industrial 1 zone.
To be removed?
To have them on a property at all.
Right, but the question is, have they been removed?
I haven't personally seen it. I'm saying that as of May 31st, they weren't removed, and as of June 12th, they weren't removed. They were still on the property. I haven't checked it since then, so I'm not sure if the containers are still there or if the mulch pile is still there.
So the wood chips are still there, and the reason that but the trailers, the containers are gone. At least that is what my client tells me. Is that correct, Joe?
Yes.
All right. And the reason that they weren't removed by May 31st was, and Mr. Richelli knows that because I emailed him this, and I emailed the Wetland Commission members this as well, as number one, Mr. Rashi, my client, suffered a work-related injury prior to May 31st and was out of work for 3 or so weeks, and was unable to get these things moved. And the second thing is that Mr. Rashi's father passed on, was it June 2nd? And had been very sick before that. So between the two of those things, he was unable to complete this, mainly the injury, but also time spent with his father. And so they are removed now, and you know, things happen in life. And these trailers have been there for I don't know how long.
The trailers are removed?
Yes, basically they call them sea containers.
Right, but they're gone.
Yes, all 4 of the sea containers are gone, the blue trailer's gone, the grinder's gone. He says, John, he says, we've got the mulch pile back there still. I says, just, because that's gonna take probably a couple weekends to handle. He says, we're talking about going.
July 7th, the Wetlands Commission gave an extension until their next meeting at July 7th to have it removed, and the plan is to have it removed by then.
So do we have any photos? You said you didn't go out, so you haven't seen that the containers are gone. Did you bring us any evidence just so we have it on the record that the containers are gone? Not that I don't believe your word, I do believe your word.
We did not bring anything. You're welcome to leave the hearing open. We're going to ask that the next one remain open anyway, the 130 Shaker Road, when we get there. So.
Okay, so let's not talk about that. That's the other part.
Right, but my point.
Okay.
My point is, we're going to ask to come back next month anyway, so if you want to leave the public hearing open, and then, you know, Mr. Richelli would have enough time to go out there and see, he's going to go out there and see for the Wetlands Commission by July 7th anyway.
I want us not to mix our metaphors here. Let's just stick with the one we have open. We're talking about the multi-family, the family
Yep,
thing.
and that's where that's what the Wetlands Commission has the interest in.
Okay. So okay.
By July 7.
So are you asking us not to rule on that one tonight either, and just to let this?
If you want an answer to this one, the 174 house property, and you want to make sure that the wood chips are removed, then I'm asking you to leave it open so that we can satisfy that.
I can have a picture of where the trailers were. I didn't have my daughter.
She needs to be at the dais
Yeah.
and come up
You
and
come up.
speak.
Where's that? Do you have that file?
Why don't you let Terry sit there, Joe? Just go right to the back row for now. I'm not sure you can.
It's by agreement, but we have to ask that question. Because I think we'll continue to be mandatory.
My name is Teresa Ekstrom. I reside at 174 Shaker Road. My daughter is at the house right now. She can go outside in the yard and take a picture of where the containers were and text it to me, and I can show you with a photo that where the containers were and that they're no longer there, if that's something that you would want to resolve this evening.
How about at the moment, we take it under advisement so that we can take what you're asking us to do, continue? Thank you. Just my 2 cents.
Yeah, no, I think that's fine. So Rick, are we able to allow them to continue this, or?
Well, you could, or you can make a decision. The other issue is the cease and desist order dealing with the industrial use of 174, which you appealed also, right?
We appealed, yes, we appealed everything, but there is no industrial use there.
Well, so let me clarify. When a cease and desist order is issued, it's because of a violation on the property. The violation cease and desist order dealt with the containers, dealt with the use, because that property since 2022, when the same violations were found on the property, they continued since that point in time. So when I issued the cease and desist, the violation still existed. The appeal is for a violation, or is an appeal of the cease and desist order for all of the violations, not just the residence one. So at the time the cease and desist order, they were, as far as I'm concerned, they were still in violation because there were containers on the property, there was a pile of mulch. He operated the wood supply, chopping or firewood from the property. Now not that I want to get it confused, but it's also being operated from 130 Shaker Road. So, as I said, the appeal is for all the violations that were issued or in the cease and desist order. And at the time, as far as I'm concerned, there was a violation, otherwise I wouldn't have issued the cease and desist. And that's what's being appealed, so.
Right. And we can vote them separately with, when we go through this.
On the season,
Yeah.
right.
I actually think I withdrew the appeal at the beginning of the last hearing for the wood chips and the trailer, because we had already told the Wetlands Commission we were moving those. My client was moving those. Not we, I'm not going to help, but my client is going to move those. So I believe we withdrew that at the beginning.
I'm not sure, we'd have to check the minutes.
I thought he did too.
Yeah, I think you did too.
Right. I mean, the cease and desist that we're focused on at the moment
Well,
is about the two-family residence.
that is correct.
Number 3.
But at the time the cease and desist was issued,
I understand.
and the appeal, the appeal was for all of the violations, just so
Right.
you're aware of that.
But it looks like some have been taken care of.
Or they've withdrawn their appeal, which means you
Well,
can go forward.
That may be the case, but was the cease and desist order valid at the time it was issued? And I think that's the issue that's before this board.
But not if I've withdrawn the appeal as to that matter, then it's no longer before the board because there's no appeal.
You're
Right.
correct.
And whatever happens to you, happens to you.
Correct.
Because if we uphold it as you're stating, then all of a sudden we tie them up again.
Right. Well, we wouldn't, we would clarify.
Separate 'em?
Yeah, we would separate them. So they've said they've withdrawn number 1, which was the containers, and
Right, I'm just-
number 4, which was the manufacturing.
Well, yeah, there's no manufacturing going on, so I don't know if we need to withdraw that one but there's nothing happening there. So I guess that appeal should probably be open. The number 4 should probably not have been withdrawn if it was. Simply because there's no manufacturing going, so we deny that there's manufacturing going on there. It's going on across the street.
I'm trying to find where they're listed. This is the narrative.
That's the other property. That's
Well, the
130.
two-family residence without approval.
Oh, okay.
But this is his narrative.
Yeah.
I'm trying to find where they're listed.
Oh, on the order right here.
This one. Right. Oh, I have a different one. Okay,
Yeah,
I've got a different one. Hold on. Let me get,
It's this document here. That's what I'm looking at. There's four
okay, I don't see.
different violations that they identified. The storage containers, the conformity of the buildings.
So when we do
The
it-
single-family home approval, and the industrial use table non-approved manufacturing
Okay,
processing.
so we're working off of this one first.
Correct, and we were trying to ascertain which ones they've withdrawn.
Right.
Do the minutes reflect anything withdrawn? Right, that's all we have to go on.
Well,
There was some,
The appeal form says on page 2, what grounds are alleged for this appeal, and there's 3.
correct, that's right, that's this, the front page looks like this.
no, he's talking about the
what
thing
they-
that
the
they
actual-
filled
Their
out.
narrative, their part. 174, is that this one? Is it on the 174, Jim?
Yeah,
Just pass it down to her, please.
This one?
yeah.
I marked it too. Yeah, Palin, yeah, I've got the same one you got. Thank you.
Okay. Yeah, she has my thing.
Thank you.
Somebody has mine, I don't know. I got it buried in here. I don't see it.
Okay.
Those were our grounds of appeal.
Right, so this is the appeal, 1, 2, 3.
Right.
Right.
Well, no, that's his
his
rash,
answer.
those are his
Right.
defenses.
And this
There-
is what
there's
they're saying
four.
over here, 4
Right.
of them.
There are four
Okay.
items,
All right, and we're not worried about this one yet.
and we just want to be sure of whatever, if we're gonna vote on him, that if he's withdrawn it, then there's no reason to do anything with it, because it's not at issue.
Right, so are we finding, could someone scan those minutes?
That's what I'm doing now.
So we looked at them quick, and maybe we
Yeah.
missed them, but we don't see anything in there, in the minutes itself as a formal withdrawal of the other violations.
Okay.
Not in the minutes itself anyways.
Yeah, but I do remember us having
I remember the
a
conversation.
discussion about it.
I mean, it might have just been about the storage containers. I don't remember.
Well, why don't I withdraw our appeal now as
Sure,
to?
yeah, sure. Tell us what you're withdrawing.
We're withdrawing the appeal as to the storage containers and the wood chip / mulch pile.
So that one would be number 2, Rick, or number 4?
Well, number 1, I get. Where's the one you just, is that the industrial use, number 4? 6.20?
That would be the non-approved manufacturing processing, right?
That's what I thought.
That's what I
yeah.
think.
So you're withdrawing number 4?
Which one's
Just
number
make
four?
Okay.
Industrial use table, non-approved
620.
manufacturing.
Do you have this
but-
document?
No, we deny that that's occurring, so we're
Okay.
not withdrawing it.
Okay.
We deny that that's occurring. There's no evidence that that's occurring.
Well, what is that mulch pile then?
It's just been there for years. How long's that been there, Joe?
Probably 10, 12 years.
So that was from long ago. It's there.
Yeah.
But that doesn't mean that he's not doing anything with it, but he is going to move it.
There's no ongoing processing.
Correct, it's across the street. We fully admit at 130.
So what we're
Rick.
looking, yeah.
I would just say that Mr. Rashi himself just said that one of the items he removed from the property was a grinder. And that was used for part of the mulch pile. I'm not saying it was used within the past year, but in the past, up until the point it was still on site, he said that was removed along with the containers and trailers. So the mulch pile is a product of the manufacturing that took place using the grinder on site at 174.
And there was manufacturing in the past there. And in fact, what year was that, that JI picture and article, like
75 or so.
when he was doing it? I mean, you know, this property was used before there was a house for this use. So the grinder was there, but there's nothing that says you can't have a grinder in your yard. But it's gone now anyway. It doesn't mean that you're using it just because you have it. A lot of people have extra equipment around.
Mr. Chairman, just a question for understanding. If we uphold all the cease and desist, but they've already resolved the issue, it becomes a moot point anyways, correct?
Right, yeah. If the issue's resolved, it doesn't.
Right, so even if we upheld the cease and desist on storage containers, they've removed them, there's no longer any issue.
Right, but there's no reason to deal with it, because he just said on
Understood.
the record he's withdrawing
Understood.
that. So we
Understood,
wouldn't.
yep. I'm just saying as far as the mulch / wood chip factor, if that's been taken care of or approved by the wetlands to stay open or be corrected by July 7th.
Right. I mean, it would still be up to town staff to
Right.
enforce this if we upheld it. Right,
Right.
Rick? Yeah.
Okay. Just thank you for the clarification.
Could I I would request that the meeting either be held open until next month or no vote occur until next month.
Why?
I'm going on vacation on Saturday for 2 weeks, and I'm not sure how I get an appeal done that quickly, based on my schedule. That's with what I have between now and Saturday.
Do we have enough, can we leave this open till next month without any problems?
We'll give you an extension of, we have
Okay.
65 extra
Rick
days.
said it's fine, and
Okay.
and the applicant agrees, so
And then he can clean up his loose ends and,
tell us it's all set.
right. So that would be on the first one. We're not on the second one yet.
Correct.
Yes, Rick, you're looking at me like want me to read your mind. You want me to do a Vulcan
Yes.
mold here?
Tell us what you're thinking.
No, that's fine.
Okay.
Okay, so you're gonna write a document that's gonna give us permission to hold you again, because you have to give us that extension.
I'll do it right now. It's a one-liner.
Rick, you
Just,
good?
I may not be here next month, Mr. Chairman, so numbers
Okay.
may be a factor. Just so you're aware.
Right. And what about our other member?
I'll come back.
We'll give another extension if we have to. If there's not a quorum or we don't have 5 for our vote, we'll give another extension. That's fine.
Can we keep doing that?
I don't think you can do to August unless you have a special.
We don't have a meeting in August.
I know, that's what I'm saying, unless you have a special meeting prior to the run out of the extension of 65 days.
Because my problem is I'm traveling in August. What's the month? If we were to have a meeting?
Yeah, August doesn't work for me, so I won't be here. So we
So
have to-
when-
if we extend it to the July meeting, we have to be sure we can deal with it then.
But what, you're traveling?
It's highly likely I'll be gone on that 27th.
What's the July meeting?
So I've had the situation before, and the town attorney for Summers had agreed with us with, it was a zoning board of appeals matter, and we went over the time, and as long as the parties agreed, the belief was, because the time frame is really, the statute is really designed so that the town doesn't hold up the applicant or the developer or whomever, that if that person is willing to waive it and nobody else has an issue with it, it can go longer. That is the ruling we had. Now, you could certainly check with your town attorney to see if it could go longer than that.
Is there a reason why we wouldn't decide tonight?
Well,
He's asked us.
He's asked us to continue, stating that he plans to get his corrective action done by the time he's back here in July.
Right, which is the inlands and wetlands. And basically what I'm hearing, this would be held until September. This would have to be held
Well,
between.
No, I mean, he would be at wetlands in early July, and we
Right.
would be meeting at the end of July, and more than likely, we would vote on
But
it.
he's not going to be here.
Correct.
And then maybe Christine might be here.
But we
He
don't
may
know.
not, right, he may not have 5 votes.
Right.
What are the issues? A mulch pile and whether this is a house with an in-law apartment? Is that all that's open?
No, there's the other,
Well, the
there's one.
manufacturing.
Yeah, well, the manufacturing, which we deny, is occurring. The mulch pile, we've said, is going to be removed, and it will be.
Okay,
And then
so
the
we-
house. The house is the big issue.
So Mr. Rochelle needs to go and confirm that there's no manufacturing going on? Is that the idea?
Yeah, I mean, I guess, I mean, I don't know how we prove a negative.
I guess the only issue would be the mulch pile is the product of the manufacturing. If they're going to remove it, then it becomes a moot point at that point also. So I think the only thing before you to make a decision tonight is that of the in-law apartment, and I think everything else, if they're withdrawing the other two and you give them an extension, or they have until July 7th to remove the mulch pile, then the only thing really you should be deciding, I guess, is the in-law apartment aspect of this.
So,
I'm ready to vote on that.
Right. I mean, so we could table the other items and just vote 3.
Okay, and just so we're all on the same page, I can show up here in July, but I can't show up here in August. You can't show up in July. Christine may not be able to be here, which means another person, it's possible you won't have 4.
So-
5.
But if we resolve the house,
The house thing we could resolve, but the other ones would have to stay out open.
Right.
To me, it's September.
but he may withdraw the others.
So
as to this
it'll
if
be a
he's
moot
taken
point
his
if all
correct-
goes
right,
clean
so if
in
we,
July.
If we handle 3, we leave him the chance to just withdraw the others when he
So
comes
then
back.
we could just leave those open.
Right.
And just do the cease and desist on 1.
the only concern I have is if we are not successful with our appeal on the house, I have to file an appeal and have it ready to roll before I leave for vacation on Saturday. And I'm not even sure your legal notice gets in the paper, and I have to, reference that legal notice being published in the appeal. So I don't know how I do that, and my partner's on vacation with me. So, and I'm out of state.
So I'm just trying to make you understand our dilemma with your dilemma.
Yeah.
Right.
I understand,
And we can't,
but I don't know how I.
We
how I-
don't know how to read the crystal ball.
no,
here.
we cannot. So unless we can, and all I'm saying is, I'm pretty sure all of us could be here for September. That's how long
Yeah.
this would have to stay open.
And I'll give you an extension till September.
Can you do that? Does it matter to you?
They're the parties that are appealing, so I would think that if they give you an extension to September, it would
Suffice.
suffice to rectify the situation as it exists right now.
I just think it would be easier if the team that's here can all be here again. And yes, it is summer, and I get you.
And by the way, he's going to ask the same thing of the other property, so we have reason to deal with it all then, too.
At the same time.
Sure.
Are we good with that?
Yeah, that makes sense to
Do
me.
we need to make a motion, or does he just make the offer?
Well, I think he needs to, he's made the offer, and I guess he could tell us whatever he wants to tell us on the other one, and we can just do them together.
Nah, he's giving us the look.
Okay, you want to do it now? Do it now.
No, there's no reason why the other one should go any longer than what it already is, as far as I'm concerned, 130 Shaker Road. You should be able to make a decision on that tonight.
So let's not mix them up. You want us to
Okay.
finish this one
So-
before we go to the next one?
Right,
Okay.
so giving an extension, as long as he puts it in writing and gives it to the board right now, extending it to
September.
then there shouldn't be an issue legally for that to continue.
Do you know that, I was just
I
going to
can
look on
tell
the
you.
calendar.
The 28th,
September 28th?
correct.
And if you want to make that motion, Mary.
I can do
Ann-
it now?
Yeah, you can make the
And-
motion.
okay,
He-
so I
he
make
said he's
him-
extending.
Okay, so I make a motion that we
Accept this.
accept his extension
Yep.
for ZBA 2026-410A. Do I have the right one?
Yep. 174.
174 Shaker Road.
To
Of
the,
appeal to the zoning enforcement cease and desist order and violations of sections 3.30.14 and 3.00.1 and 620. Are you sure I'm in the right one?
yeah,
Okay.
yep. And then to the September meeting.
To the September 28th meeting, 2026.
Do we have a second?
Second.
Second. Okay, all those in favor of extending it? All right, so this one will be continued out.
I'm gonna vote no on that one,
Okay,
Yes.
to not extend it. Just so
Okay.
you have me as a no-brainer. Just because I'm doing all, just so you're aware.
Doing all of what?
All of them. So I just voted no on that. You voted yes.
It's not pretty, but.
Did you officially withdraw any of those?
Yeah, the storage containers, we withdrew. And I think that's it.
Do we need to read this in a record?
no, but we need to put it into
Okay.
the record.
Yeah, do you need to give it to him? Okay. So we're keeping all this stuff.
Yeah, we're keeping that pile, so keep it clipped together.
Okay, is this 170? No, this is 130.
Stuff on 130 is next.
What is this?
This is the,
Oh, this was the fire department. We're done with them.
yeah.
Okay, and we're keeping all of the, that stuff they just gave us. Keep this,
Yep.
and we'll keep the old minutes. You gonna bring us 8, 9, 12, 15 more?
I hope not. My file's always a lot lighter when I leave here, though, than when I come in.
30.
Yeah.
That's the next one.
Correct.
It's just, I'm sorry, I'm just a little confused by,
Well, they're on the same street and they're
okay,
the
these
same
are all,
owner, so.
okay, these are all 174s.
Yeah, make sure you save all that
Yep.
file.
Everyone's gonna need their envelope back.
No, I don't. I have a file folder.
I'm keeping one of them. Okay, you don't need this. So do we motion and approve and we're done for the moment? We
Yeah,
don't
we're
have to
done
do-
with 174 and
Okay.
he's gonna talk to us about 130.
All right, so I am going to be asking for an extension for 130, and, but for different reasons. So first, let me ask Mr. Rashi, to your knowledge, how long has this property been used for timber processing?
For at least 50 years.
At least 50 years, and how do you know that?
Because I grew up next door. I mean, it's just down and I've seen, Pop Moody's tree service going in and out with loads of, brush, wood, and everything else.
All right.
That was one of the major reasons why we bought the property, because we figured it wasn't gonna be a problem. This is, continuation of work records on, we've got the cease and desist for 174. So, because of the house, we basically, that's what we were told anyway, this is drawn. So then we went and purchased, 130 to avoid the problem. This is drawn, it was back in 2020, we bought.
2020, I think.
This is drawn, just to get out, just to get ahead of it. Then, like it says, then all of a sudden he come after us over there. This is drawn. So, I mean, at that point, this is drawn. I said, right now, we've got a surveyor over there trying to get.
Yeah, let's get there in a second. So, I've researched, and all of the case law that I find on this subject, other than one case, and that case is so convoluted and written so confusingly, that and it's a Superior Court level case, but all of the cases have to do with pre-existing non-conforming uses. This is a conforming use. It just doesn't have a special use permit, but it is allowed in the industrial zone, which this is. And this property has been used like that for years and years and years. And although we don't have evidence that a special use permit was ever granted, nobody can say that it wasn't either. I don't think anybody's gone back 50 years or more to take a look through everything. So what we would like to do is, my clients have hired Richard, is it Richard LeClaire? Gary LeClaire from Windsor Locks, who has been out there and has, I think, pretty much completed the survey, the field work for the survey. And next week, Terry? Yes. Next week, he should have a site plan pretty much prepared. I need to speak with him. I was under the impression initially that, and I haven't spoken with him, but I was under the impression that he was preparing what was necessary to submit to planning and zoning for the special use permit. But I was informed tonight that that is not the case, so I need to speak to him to see whether he's going to do that or whether I'm going to do that. But we are moving ahead with, just because it's cheaper to do that than to appeal. Now, what I don't want to do is have to do both. So I would like to leave this open so that we can go to planning and zoning and get the special use permit that we believe we will receive, because this property can comply with the requirements. And it's been used like this for 50 years. There's nobody living right next door there. I mean, it's 10 acres. It's already being used like this. The property's already cleared and processing is going on. So if we can leave it open, then we can hopefully get this and it resolves this issue. If we have to close it, then I have to take the appeal to protect my client, and I don't want to do that. It costs my client money, it costs me time and aggravation, and it costs the town attorney or whoever the town is going to hire time and aggravation and money that the town can better spend elsewhere. We don't need to make new case law on this case. So I'm asking that it remain open, that my client be allowed to make application. There's no harm that's going on. There's no threat to public health and safety. This has been going on, to my knowledge, and Mr. Richelli can comment on this, there have been no complaints from anyone regarding the operations over there. He's not disturbed, my client's not disturbing anybody. So I would ask that, you consider leaving this open. It's a tough situation for my client, who thought he bought a property that allowed this because that's what had been going on for 50 years. He never thought he needed the special use permit, and so he didn't, he just bought.
So, do we need an extension for that too?
You would need an extension for that too.
If you're looking from my point of view, I think it should be heard today, and you should make a decision on it. This issue, again, goes back to 2022. And In my report on 3/7/22, I received a call from Mr. Rashi regarding both 174 and this issue with 130. And Attorney Schober was aware of the violation regarding 130 back then in 2022. It's a violation. If you ignore what I do, then there's no sense in me issuing a cease and desist on any violations. It just doesn't make any sense. And as for,
Are you saying that to us?
yeah, I mean, yeah, so I go out and I do a cease and desist for a reason. And if someone comes before you and just asks for a continuation, just because it's not, was there a violation? Did I issue the cease and desist? And was it a valid cease and desist at the time? That's what you're making your decision on. Now, they can make all the efforts to go before planning and zoning and get an approval, but were aware of this requirement back in 2022, and nothing was done. And I'll take responsibility for not following through back then also, but there's photos that you received showing the activity on the property. There was nothing like that when it was owned by the prior owner, and this operation is the same or similar to what's down on Mullen Road for the mulch factory down there. You need a special permit for it. They were aware of it back in 2022. There wasn't any effort to make it right then, and now they're just asking for continuation again, and there's no reason for it. This board can make a decision tonight based on the facts before them. And I certainly have photographs going back to, I think, 1934 and up through 2006 that show that the activity wasn't taking place on the property. And use is not something that is considered under the 3-year rule. It's only structures for any type of non-conforming activity that's going on. So this is similar to other cases we had where uses are not considered, if they've been over 3 years, are not considered legally non-conforming just because they've been going on for a long period of time. If they were going on prior to 1925, when the regulations were created, then that would be a legal nonconformity. But any time after that point, it's still a nonconformity that doesn't fall under that 3-year rule for a use.
Now, I'm not trying to argue that this should fall under the 3-year rule for non-conforming. What I'm saying is this is a conforming use, so the rules are different. This is not a restaurant in a residential zone. This is a timber processing plant, not plant, but operation in an industrial zone where it is permitted. Now, as far as whether or not Mr. Richelli issues a cease and desist, and if there's an extension to bring, the idea is to bring the person who is not following the rules into compliance with the rules. And that's what's being done here. Mr. Rashi is applying, we're going to apply for the special use permit, and that's why the surveyor's been hired. And it's not that we did nothing in 2022. I actually walked the property with Mr. Rashi and his brother Paul, along with a surveyor, and he was going to design a site plan, and we were on the back end of his list, and it just never happened. He had told us it was going to be 6 months, and then he just never responded after that. So it's not like we didn't follow through, but we did make at least the effort to try to hire somebody. And
But when he didn't follow through in 22, what took you so long to get to 26?
the next cease and desist. I mean, that's, yeah. But if the idea is to bring my client into compliance, that's what's happening here. And so I'm asking for the extension so that we don't have to appeal. Because again, I have no choice but to appeal for my client because they're giving up the rights, because I believe that they're allowed to continue operating without any special use permit. There isn't a case that I could find either way on this. And so I prefer not to make new case law, but in order to protect my client, I may have no choice.
Where are you on the planning and zoning agenda?
Well, we're not there yet because the surveyor will have the site
Okay.
plan, I believe it's next week, Terry? They're hoping to have it next week, in which case we hopefully get on for July. I don't know when the meeting is, but.
Mr. Chairman, if we uphold the cease and desist, the ZEO has the flexibility to grant whatever leniency he needs based on progress move forward, right?
Yeah, I mean, it's up to him if he sees, ball in his court. If there's an
Because we won't have
application,
visibility between now and
you could-
September
you
of what's
could
going
decide
on.
to
Right, the next step in this is if the violation continues without any effort moving forward, then a citation would be issued
Right.
with fines.
Right.
And as long as they stipulate or give us an approximate date for the submission of a special use permit for the operations within a reasonable amount of time, I'm not saying 2 months or 3 months, I'm saying within the next month,
Sure.
that no citation or further enforcement action can be taken, or would be taken.
So we wouldn't need additional case law, using your example here. And I understand and appreciate that does take time and energy, but as long as the ZEO is seeing progress move forward, then any punitive action that the town might take could be withheld until the action, right, until it's scheduled or at least shown progress by your client.
It could be. The issue is if the surveyor is delayed for any reason, and again, I haven't spoken with him yet, but if the surveyor is delayed for any reason and it's not submitted until, how often does planning and zoning meet?
Twice a month.
Once a month.
Twice a month?
They'll meet in
Okay.
July.
Huh? I'm sorry?
They will meet in July. They're off in August, just like we are.
So if for some reason the site plan isn't,
But I'm hearing you, but I'm hearing 22 too. I'm hearing you. But we need to do something. And so you have an option. He's telling you that move forward, keep moving forward, and showing you're moving forward, your life gets easy. Your life gets bad if your guy doesn't follow through in next week or two. Keep Rick informed. Life is easy.
unfortunately, things happen. Whenever you're dependent on one person like this and something happens, then, and that's why we're asking simply for an extension, so I don't have to file an appeal. Well, otherwise, I have no choice
You
but to
do
file an appeal.
realize this is, your problem does not become our problem.
I understand. I'm
Okay.
just asking for some consideration for someone who's doing exactly what was done there for the last 50 years. That's all I'm asking for.
Well,
I
and
don't
I-
think it's unreasonable to extend this another couple of months
Well, I
while
think-
my client brings things into, attempts to bring everything into compliance.
And the nature of my question to the ZEO was to identify that there is leeway that he can give, provided there is progress made, right? And that, I think, again, I'm hearing 2022 as well, and I know that that surveyor failed you, right? And here we are again, it's 4 years later. That's my concern here, right? And I think if we give the power back to the ZEO to say, yes, you were right to issue this, just show him progress. And tomorrow, call this new surveyor and say, we need that, don't drop the ball, type of thing.
have no
I
choice
realize you
but-
have no,
I have no choice but to appeal.
that's certainly,
And it
certainly
costs
you're right.
everybody- I have no
Understood.
choice but to protect my client and take the appeal. And it costs everybody time
How
and
much
money.
time does he have to, is it 15 days after we rule?
Yes, after
Correct.
the notice is
Notice
published.
is in the paper,
And when will the notice be put in? Tomorrow, the next day, this week?
probably by Friday,
Because you have to put it in there that we did this,
yeah.
whatever we do.
In which case, I'm on vacation starting Saturday, so my appeal has to be drafted. I know that's not your problem, I get that. But
Question, Mr. Chairman.
Sure.
If Gary Leclerc, he got something from Gary showing that they're working on it and gave it to Rick to show that progress is being made, is that enough to hold you back from doing an appeal?
no, because once that 15 days is gone, I can't appeal. My client,
true.
and we think that, my belief is that my client does not even need to file for a special use permit. But I don't want to go through a year and a half of litigation when the money that he pays me instead can be used just for the special use permit.
Okay.
I like the July idea, though. And then,
But I'm telling you right now, You're losing one of your members. He's not going to be
That's okay,
here.
we're gonna listen, if you vote, I know I'm losing this appeal to you. I get that. So I don't care if you have 4 people here, because I'm not getting 4 anyway. I don't care if there's 5, I don't care if there's 10, I'm not gonna get 4, I don't think. So give me to July so that we can show some progress, and then we can, hopefully we have a site plan, hopefully it's in position to be submitted. There's there has to be a public hearing on a special use permit, so there has.
That's not us.
I understand, but my point is it doesn't happen, none of this happens immediately. It's probably September by the time my clients actually get approved going through the Planning and Zoning Commission.
Okay.
So if you can give me to July and I can satisfy Mr. Rochelle that we're making progress, then we don't have to take an appeal and everybody's relatively happy.
Well,
And I'm talking myself out of work here.
Mr. Chairman?
Yep.
Mr. Rochelle, what would you need to show progress moved? What would,
A site plan, a viable site plan of some sort, and an application with a narrative explaining exactly what they're going to do within a reasonable amount of time,
as a starting point?
as a starting
Which
point.
they can do tomorrow.
Notwithstanding planning and zoning schedule and public hearing and all the other, like, that's not relevant
We
to the
get
scenario.
applications in that are not complete numerous times for planning and zoning. We have to go back to the applicants time and time again to get what we need for those applications to move forward. And if we got a partial application regarding this, then it would move forward. Now, with the extension, with all due respect to Attorney Schober, in the past, this board has given extensions numerous times, and they haven't gone through fruition, should I say. We've gotten, there's some that we still have not gotten for years, and they're still hanging there. And I'm not saying they would do it, but I'm saying that's the history. And the issue, again, it's not our issue or our problem regarding the appeal. And then even if it was an appeal, if they submitted an application, it's going to become a moot point going through court. I understand he has to file it to protect his client, but we've had cases where they followed through with planning and zoning, and the appeal has been dropped at the court. But again, that's not our issue. That's the property owner's issue. And if this was a first time out of the blue that just started this year, I would say, okay, some leniency on my part, even more so. But this has been going on since 2022. They're fully aware of it. They were fully aware of it back then. And again, I don't see any reason why the ZBA can't make a decision on this tonight. It just seems redundant in asking for another extension again for this matter. It's not our or your situation to take that into consideration, I don't think. But I don't make the decisions, the board makes the decisions.
And through the chairman, to Mr. Rochelle, I completely understand the hard work that you go through to do the best for the town. And when you bring it in front of us, we try to weigh it. But I don't want you for a second to think that we don't take your hard work for granted. I just don't want that on the record. 'Cause
No, I don't do that.
I know that you put the effort in to follow the letter of the law, and I need you to understand that.
Oh, I
He's
do
trying.
understand that. I'm
So-
just asking for a little consideration for my client.
You have,
And for me, for my vacation schedule.
Just to let you know, I'm on vacation too in July, so.
Yeah, but you don't have to draft the appeal between now and
I
Friday.
do not, I just have to type up all these reports.
And on top of everything else.
damn holidays.
We gotta make a decision here.
Well, it's either we push it to July or we vote.
Tell me what you want to do. Somebody make a motion.
You know, we'll see how it goes. I'm going to make a motion to close the public hearing, unless there's other questions to be asked.
Nope.
Well, I don't think this is a public hearing.
Yeah, it is.
No, that's what we call it?
Oh.
Okay.
Then what motion would I need to make? Was that the correct motion in this scenario? Because
You'd have
Well,
to make
I
the
think-
motion in the affirmative to
To uphold.
uphold the
Okay.
appeal.
Right, it's this
okay, so I'm not
motion.
making that motion. You would
Right.
be. I withdraw my motion to close public hearing.
Is it a motion to adjourn?
Well,
Can't do that either.
can't do that. No, I mean, you could do a motion to continue if somebody wanted to, and somebody could second that. We could do a close. If you do a close, then you could make a motion to
Close.
uphold.
To uphold or deny the cease and desist.
So
Okay.
what
so
motions do we have?
I'd like to make a motion to close.
Do we have a second on the floor for
I will
that?
second that.
So you want me to read the motion to approve?
No, let's.
Start with
we'll
that?
Start with the motion to close and let's vote it. A roll call on that.
Andrew Abanowitz.
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy.
Yes.
Rich Stroni.
Yes.
And James Byrne.
Yes.
Okay, everybody wants to close.
Okay.
Next.
Make your motion.
Okay, I make a motion to approve, wait, that's not the right one. Let me get to the right one. Motion to approve ZBA 2026-4-10, 130 Shaker Road, appeal of the zoning of,
Oh, I'm sorry.
my,
Ignore me.
No, that's right.
That's right.
Keep
I'm
going.
getting confused
Keep
now.
going.
Keep going.
appeal of the zoning enforcement cease and desist order for violation of section 6.20. Joseph Rashi, applicant owner, map 81, lot 216, I-1 zone. So I made it.
Yep.
Second.
Rich seconded.
Discussion, is that where we're going?
Yeah, we
Yep.
can do discussion.
Hit it.
My view is, as I've asked through the ZEO, which is there is still room for the, was it appellant? In this-
Yeah, I mean.
In this case, to show progress towards corrective action prior to any fees or any other punitive responses from the town. And I think that's all the ZEO is looking for at this point, if we uphold the cease and desist. And I think that because this happened since 2022, it's been this scenario. I think there's been plenty of time given for special use permit as required, as discussed by the town.
I understand, through you, Mr. Chairman, I understand the applicant's request to give him another 30 days so that everybody can kind of like get their ducks in a row. I guess the question is, if we do our business today and uphold the cease and desist or not, would it matter if it was today, or would it matter if we waited 30 days? Because we're coming back anyway.
With the motion that's on the table, is postponement an option?
You'd have to withdraw that motion and make another motion.
Or you don't uphold the cease and desist, correct? That's the other
But
option. Because that's the
the-
motion here, it's to uphold the cease and desist.
The
Well,
thing
then
is,
that
the
takes
cease,
it off the table.
Right.
yeah, but the cease and desist is valid. The way it's written and what he's
Right.
going for, it's valid. And I understand the 22 just, to 26, that's a big window.
So I guess your question is,
If we postpone it, we can moot the whole thing, and this goes away, and we'd know
All it's
that.
doing is allowing the attorney to have time so he doesn't have to file right today, because he's right. 15 days is it. They either file the appeal or it's dead, and that's the end of it. And then we have, even if they come into, they have to go to court and all the rest of that jazz.
Or in 30 days, the site plan and the all that paperwork is submitted to zoning.
But I don't think that stops the cease and desist. Once we vote to uphold or deny, if he doesn't file,
Let me ask you this question. Let's say we upheld it today. Does he have to cease and desist, or is there an appeal
yes, he only
period?
has 15 days.
No appeal period?
You
Well,
can't,
15 days.
interact with the audience during discussion.
It's 15 days.
Right.
That's it.
from the posting of the
From
notice.
the posting of the notice.
No,
And-
even if he files an appeal, he would have to cease and desist.
No.
No, the appeal,
No, the appeals stops. at
right,
that.
the appeal just,
The appeal would stop the cease and desist so that he can continue operating during the appeal.
for
During
him,
the pendency of the appeal, right, or concurrently, he could be applying to planning and zoning for site plan review.
That's probably what would happen.
Well, that's what we're hearing.
Right, that's what we're hearing is exactly what he would do, is that
Right.
he would appeal, and he would also be applying for site plan review, and at some point, once he has his site plan permit, withdraw the appeal.
And would be operating during that time period.
Right, but he would be operating, yeah, one way or another. If you guys retracted your motion and your second and gave him 30 days, he's still operating. Or he appeals and, you know, I don't know that it changes that.
I think the only thing it does is if we pull this off the table, he gets that extra 20 days. I understand, it's July. I mean, it's our vacation schedule, and I'm not sitting there saying we should be so flexible, but I think the applicant I want to take him at good faith, that they're moving in the right direction, and if they don't,
So you could withdraw your motion, you could make a motion to extend to July, and
no further than.
And you could say that you're not going to give a further extension in that motion, if that's what you want to do.
What do you guys, we're in discussion mode, gentlemen. Hey,
I've said my
spill
piece.
your beans.
Maybe that's not a bad idea to build it in, that he can't go any further than the end of July, or whatever July's meeting is.
That's fine with me.
That's fine with me.
At least you're putting a date.
I think this is something that could be resolved tonight, and there's flexibility on the zoning office to.
I'm not,
agree with you there.
that's
And
all
that-
true.
that's my
The
position.
problem is, it's the cost, this starts a dollar.
I understand
Right.
that.
This is a bank account.
No, I
And the
understand that.
applicant's the one who's gonna pay him. He can go on his vacation all he wants, but he's gonna put on, I'm looking at the applicant.
Right.
They're our neighbors.
No, I know, and I know.
So
And
I
he's-
would-
and
I-
he's, you know, it's him having to engage somebody else to write this appeal, the applicant spending, you know, $6,000 more money to
That
just
they
be
sh-
in the same place he would be if we gave him
30
the
days.
30
Which is
days.
money that could be spent on the site plan.
I would like to remove my motion and give him the July 27th.
Okay, so you're making a new motion.
I'm making a motion to remove the original motion to approve the cease and desist and give them till July 27th. Is that where you're talking, Mr.
Yes.
Master Birdie?
With no extension.
With no extensions.
Okay. Do we have a second on that revised motion?
Second.
Okay. Please read the roll.
So if we vote yes, we're holding the extension.
Correct. We're going to extend to the July 27th as the final extension. So,
Andrew Master Birdie. I'm sorry, Jesus. Andrew, I
Wow.
gave you a
Yeah, I
different
got a
last
new
name, and
name.
I'm
I'm
talking to
joining
you.
Charlie's family.
Andrew Urbanowitz.
yes.
Excuse me, 1 second.
Yes.
Yes,
So you closed the hearing.
Yes.
You made a motion to close the hearing.
correct.
If you're going to take something into consideration at the July 27th meeting, you're not going to be able to do that if you already closed the public hearing.
Well, we could vote then. So that you would need to
We're just gonna-
revise add that to your motion.
Okay, hang on, let's make sure.
I'm just, so you won't be able to take anything in for public
Evidence.
input or evidence in
Right.
on your
We're
decision
gonna have
on the
to vote.
27th because you already closed the public hearing.
But
Well,
we will still know what has happened.
By them telling us, not by them telling us.
Right. We're not
That
going to
true?
have any testimony.
That
Can
staff
you
would
tell us?
I won't be here to tell you, but somebody will tell you.
But
I'm
we
hoping.
could hear that answer from the staff.
If there's any movement forward, yes.
Okay, all right. So we can let the public hearing stay closed, just want to make sure we're on the same page, right?
Yeah.
Because we're
we
not
closed
taking
it.
anything from him, but the staff can inform us.
Would we be allowed to reopen the public hearing then?
No. Once we close
too
it,
late
it's
now.
over.
It's closed.
This is already closed.
Right. So we can extend the vote, which accomplishes what they've asked of us to have more time.
Right. All you'll be doing in July is extending the vote formally. There won't be any
Right.
other real discussion at
Right.
that point.
We're voting,
And then July is the deadline that
that's it. The
that
vote
they'll
is-
have.
Right,
That's the day the vote's happening. So revise the motion.
Steven, you're gonna be here, right?
I don't have any plans to be away at that date, so I can be here.
Let's try this again, and I'll give you your real last name. Andrew Ivanowitz.
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy.
Yes.
Rich Stroni.
No.
James Byrne.
Yes.
Okay.
4.
Motion
You get your
passes
extension.
4-1.
Thank you very much. You made me work.
You made us work, and you made us not, I'm gonna have to start baking for my CEO. So,
Have a good night.
Thank you.
We'll see you in July. Thanks.
Yes.
I'm gonna need a new one of these, right? Well, maybe not. Maybe, yes, maybe, who knows? Stuff it in here.
Right, I mean, they may come in and they can still withdraw. They don't have to let us vote.
Okay.
It'll be the test.
So, am I allowed to talk about this?
No, not yet.
No.
Okay, so moving on with the agenda, we don't have any new business. We have approval of minutes, item 7. And it was called to our attention on page 2 at the bottom that 130 should be 174.
Right.
With those revisions, do I have a motion?
So moved.
Second?
I'll second,
Okay, and then all those in favor of approving the minutes as revised?
and I'm gonna abstain
You're
since
gonna
I wasn't
abstain.
here. Yep.
Okay, so four yes, Rich abstains. Correspondence and staff report, anything for us? Sensing nothing?
Nope.
Other business, anybody?
I have a request
Okay.
to the staff. It's confusing. When you send me a packet, I read it. And I guess where I need to learn is that you're not putting everything in it, and that I'm supposed to go online and look. Okay? I don't know how to change this.
It becomes difficult for us to have to print stuff to bring it with us. And we would just prefer to have it printed so we can do our job.
Or leave me a very large note across the top.
Right.
Go look it up online. You don't have everything here.
So not to be argumentative, just trying to be a little bit clarifying. From staff's perspective, it was our understanding that if we had provided you all the iPads, that you would then look at all of the information through the iPads and kind of negate the need for as much paper as we had sent out in the past. So
If you had bought us new iPads that actually functioned, again, not you, but the town, we could probably make that happen, but.
are you having issues with the iPads? Is that what I'm hearing?
Yeah, well, not you. In general, they have scheduled 2 or 3 meetings to have the iPad girl come in and give us a training class, and she has canceled all of them. And my calendar is extremely tight, so I try to fit her in.
Right.
She can't cancel. So, you know where my iPad sits? In my office, on my
Right.
desk, unplugged, dead. And for me, I don't have any problem going into the website and looking. I just maybe need a little nudge to be reminded, go look.
Okay, and again, I'm not trying to be argumentative. I'm just trying to clear up whatever confusion we have here. Because my understanding was that, well, yes, she did cancel
Twice.
1 or 2 of them. 2 of them, thank you. I do believe she still held the last one, and that was, I want to say either late March or late April.
No,
one
no,
of those 2
no,
months.
no. Nice try.
Again, this is my understanding.
There was one meeting when they were handed out. I don't remember what month that was. And then we had issues after that. She had a meeting downstairs that I went to, and I don't think anyone else did. She got it set up, and then when I bring that iPad up here to the second floor, it does not work.
There's no Wi-Fi in here.
Right.
So and again, just trying to understand what's happening. Is the issue with the iPads that you don't have the connection in the council chambers, not necessarily the iPad itself?
Well, the
Yeah, that's
iPad
bad.
itself is old. I mean, it's like 5 generations behind the one I have at my office. So that.
So if I may ask, would a newer iPad potentially fix whatever our issues are that we currently have with them?
I mean, assuming there's Wi-Fi in here, yes, it would, because we could go on it and pull up the document.
Right, because right now my computer is connected to the town's Wi-Fi, and that's how I'm able to
it's those
pull up.
old iPads that we're having the issue with then. I think that's the
So the
problem.
issue is that the iPads are having an issue connecting to the Wi-Fi.
Very well
Yeah,
could be.
in this part of the town hall. If I take it downstairs, it works fine. But we don't have a meeting downstairs all that often.
Right. So
Is there any way,
So you need a repeater.
is there any way to just add some type on, just for me, because maybe it's all about me, go read the full packet? Just,
You just need to know.
that,
just,
that,
just
that is
add
a-
it on this sheet of paper.
that is a potential option we could do. We can
Because you
push a
know what?
little, put a little
That-
nudge in the, because my understanding is you get the paper packets with the site plans in them,
Right.
but that's about it.
That's
Well-
all it should be, but it's more than that. But
Right, yeah.
Right.
That was the original
we
intention.
really only need the printed site plans if the iPads would work correctly in here, because then we can look at the rest on the iPad. But trying to pull up something like this on the iPad is hard.
Correct.
That's yeah.
I vote
Okay.
for having the paper. I like highlighting, I like underlining.
And I'll
Well-
print my own.
Right,
I'll kill
yeah,
my own.
Let me make a
I'm
suggestion.
okay
Why
with
don't
that.
we, instead of going back and forth, why don't we supply you for the next meeting with hard copies of whatever comes in for ZBA? And in the meantime, we'll try to rectify it with IT about new iPads or new
Yeah,
new
something
equipment.
newer. We don't need them like brand new, but within the last 2 years, so they would work in this room.
If it can't be rectified before your next meeting, you'll get hard copies of everything that we have until we rectify the issue with the laptops.
Perfect.
Thank you.
All right?
Moving on with the agenda, you have your town attorney's report.
I don't know, I didn't.
you read it
I
online.
didn't read it online.
We don't need an executive session tonight, so do we have a motion to adjourn?
Motion to adjourn.
Okay, we are adjourned at, what time is it?
9:50 or 8:53.
8:53.